All right, good afternoon, everyone. It's my pleasure to welcome you to our 2024-2025 Supreme Court Roundup here at the Stegner Center. My name is Lincoln Davies. I have the honor and privilege of serving as the co-director of the Stegner Center with my incredible colleague, Brig Daniels. We'd really pleased to welcome you here today. What we're going to be doing is giving you an overview of the recent Supreme Court cases dealing with environmental, natural resources, and energy law. And the way we're going to proceed is we have several different speakers from our faculty and associated with the center in other ways. We're going to walk you through each of those cases. I am a friendly but firm moderator, so our speakers have about 8 minutes to talk about the case. They're going to orient you to the case and talk about its potential implications. Once we've finished walking through all those cases, my colleague Brig Daniels is going to round us off by giving us a bit of a preview of what we might expect in the coming Supreme Court term. And then we'll have about 10 minutes for questions and answers. So you can submit your questions using the link here in Zoom. So with that, let me introduce our first speaker. Kayla Race is an alum of our law school in the Stegner Center. She's an attorney here in Salt Lake City at Dorsey and Whitney, where she focuses on environmental permitting and regulation. She's a clerk previously for the Utah Supreme Court and is going to talk to us about a really important case called Diamond Alternative. So Kayla.
Hi, thank you. I'm going to share my screen. All right. Hopefully everyone can see that okay. Yeah, so I'm going to talk about Diamond Alternative Energy versus EPA. And the snapshot of this case is that it's a case in which the Supreme Court held that fuel producers had standing to challenge the EPA's Clean Air Act preemption waiver for California's regulations, its advanced clean cars regulations. And the specific focus was on redressability. I'm going to give a little bit of background on just the Clean Air Act preemption process and the regulations before we dive into what kind of just how did we get here before we dive into what did the court actually say. So just for background, and generally, the Clean Air Act preempts state regulation of emissions from motor vehicles, but there's an exemption for California. But California has to get a waiver from the EPA. And then once they get that waiver, then other states can adopt those regulations. And the specific regulation at issue here is actually a regulation that was adopted by California in 2012. It's their first set of advanced clean cars regulations, and as applies to the manufacturers of cars and light-duty trucks, it requires that those manufacturers have a certain percentage of their fleet be electric vehicles for their model years 2017 through 2025, and that ends in 2025, so this year. And then the other part of the regulation is regulating the greenhouse gas emissions from the tailpipes of those fleets, and increasing in stringency throughout the regulations until 2025 when it stays static, but it continues. And the specific, it's not the California regulations directly that are challenged exactly, it's the EPA action that it's being challenged. The EPA actually approved those regulations back in 2013. But then the Trump administration rescinded that approval in 2019. And then in 2022, the EPA reinstated the approval of the regulations. And so that is, that's when the fuel producers sued. They didn't sue back in 2013. They sued once the waiver was reinstated in 2022. So it's a little bit of a weird situation here. Where a rule was has been in effect for a dozen years, and we're now just getting to reviewing it. Another odd thing about this is that California has subsequently adopted more stringent regulations that are not actually at issue in this lawsuit and that have their own lawsuit going on. And the court hardly even acknowledged that because it's not technically at issue here, but it is still important in the overall understanding of things. So at the Supreme Court, the specific issue is whether the fuel producers' injuries are redressable for the purposes of Article 3 standing. Interestingly, the parties really didn't dispute injury or causation. They acknowledged that the regulations would cause injury, and that those injuries are, caused by the regulations, basically because um, the regulations, even though they don't regulate the fuel producers directly, they regulate the cars and the car manufacturers. The regulations would inevitably reduce the number of gas-powered cars, increase the number of electric vehicles, and overall reduce the amount of gasoline that's sold. So, oops. The DC Circuit held that they didn't have standing basically because they failed to demonstrate any evidence or file any affidavits that the automakers would respond to the invalidation of the regulations. Again, because the automakers are the ones that are the directly regulated entities, not the fuel producers. They're saying that the fuel producers should have shown evidence that the automakers would actually change their behavior. The Supreme Court disagreed with the DC Circuit. In an opinion authored by Justice Kavanaugh, the Supreme Court held that invalidating the regulations would likely redress at least some of the fuel producers' monetary injuries, and even just $1 of additional revenue for the fuel producers would satisfy the redressability component of standing. And they said is likely that invalidating the regulations would result in more revenue for the fuel producers from additional sales of gasoline. And the court focused on the fact that both that you can make common sense economic inferences about the operation of the automobile market, but also they said that the fuel producers had produced sufficient evidence to make it predictable that their injuries would be redressable. The fuel producers, the evidence that they had was included declarations quoting California's own estimates about the results of the regulations and the inevitable decrease of gasoline and emissions. And they also quoted the California's own request to reinstate the waiver and its motion in the lawsuit, and they quoted the EPA's approval of the waiver, and as well as 5 automakers intervened in the DC Circuit who said that the rule was needed because otherwise other automakers might come in and not comply with the regulations and hurt the automakers who were complying with the regulations. So the court said that the fuel producers could be considered an object of the government regulation, even though they aren't the directly regulated party. They might be considered an object of the regulation because the regulations seek to restrict the use of gasoline and other liquid fuels in vehicles. And basically, so when the government prohibits or impedes Company A from using Company B's product, then both Company A and B might be deemed the object of the regulations. And when you have a plaintiff that's the object of the regulation, there should usually be little question that the regulation causes injury. Sorry, I keep hitting this. And then so the regulation only has to show a predictable chain of events. They didn't go so far as to adopt the fuel producers' argument that only a minimal analysis and no evidence are needed, but they said that that argument is not without force. And they also declined to require that the plaintiffs produce evidence like affidavits from the automakers saying that they would respond to the regulation, or rather the invalidation of the regulation. California and EPA argued that this was an unusual circumstance because the market has changed over the course of the regulations and even since 2022 when the lawsuit is filed. And they're basically saying that consumer demand and the automaker's own plan makes it unlikely that invalidating the regulations would result in a shift back to fewer EVs. But the Supreme Court disagreed with that. because they said that when a government seeks to justify its regulations on the one hand by touting the consequences for fuel usage and emissions, while on the other hand maintaining that those regulations are unreviewable, then we should be skeptical. So basically, they're saying EPA in California, you're talking out of both sides of your mouth. We're going to resolve this in favor of the plaintiffs here. And they said that even though it wasn't certain that the injuries would be redressable, it is at least predictable. And again, they're gonna resolve that uncertainty in the favor of the plaintiffs.
All right.
There were a
Hey,
couple.
oh, sorry.
Oh,
We're going to move on.
okay.
Uh, we can hear more maybe about the dissents in the Q&A. And if, again, just a reminder to folks, if you have questions, please use the Q&A button at the bottom of your screens. We'll be looking at questions and taking questions at the end from all of our speakers. So thanks, Kayla. That was a really great uh, encapsulation of this important standing case and what it might mean for litigants trying to get into court. So we'll turn next to another really important issue that cuts across all different kinds of environmental and resource regulation, the question of nationwide injunctions. And for that case, of course, is Trump versus CASA. And for that, we're going to turn to my incredible colleague, Jonas Anderson, who is a professor of law here at the law school, previous interim director of the Stegner Center, and he teaches civil procedure here at the school. His work has been widely cited, everything from the New York Times to the Supreme Court to the Federal Circuit. So without further ado, Professor Jonas Anderson.
Thanks again. It's a pleasure to be here. As a interloper, I focus mostly on patent law, and the reason this case is so important is because it affects every type of law. It really is a cross-cutting case. You probably know about the details of the lawsuit. The dispute arose out of a trio of consolidated cases that challenged the executive order by President Trump. It's an executive order titled Protecting the Meaning and Value of American Citizenship. And it is the birthright citizenship order. And it basically said, the order said that birthright citizenship, which has been a longstanding thing of our Constitution, is no more. So there are three separate suits filed by a number of individuals, states, state of Washington was among them, other plaintiffs. An issue in the case is not really the birthright citizenship, but rather if courts have the power to issue a so-called nationwide injunction, or sometimes called a universal injunction, in which the court stops an act or a law as it applies not just to the plaintiffs at issue in the case, but it applies to all people across the nation. So the government, the Trump administration, sought emergency relief to stay those injunctions that the courts imposed on the birthright citizenship order. And the Supreme Court accepted the consolidated application. And the holding is basically that the Supreme Court held that federal courts likely exceed their equitable authority by issuing universal injunctions under the Judiciary Act of 1789. That basically ends the practice of universal injunctions, except some key exceptions, which I'll talk about in a bit. The court basically said universal injunctions likely exceed the equitable authority that Congress has given to federal courts. All right, so why did they decide this? Justice Amy Coney Barrett framed the inquiry as a statutory question, so it's not constitutional, it's statutory. Whether Congress authorized federal courts under the Judiciary Act of 1789 to issue injunctions that apply broadly beyond the parties of the case. And they said no. Looked at the historical roots of equity jurisdiction, and the court applied the test from Grupo Mexicano versus Alliance Bond Fund that equity relief must be analogous to what was available in the High Court of Chancery in England at the founding. And the court found that the High Court of Chancery in England did not have the authority to issue nationwide injunctions. Therefore, district courts, for the most part, do not have that right as well. The court emphasized that relief must be no broader than necessary to give the plaintiff complete relief. And so this is the first distinction the court makes. There's a distinction between complete relief, which the court has the authority to grant, and universal relief, which it means how it will impact all people across the nation. That is not something the courts worry about. All they can worry about is what complete relief for the plaintiffs is in this specific case. They didn't articulate a multi-factored test for when relief might be appropriate. Instead, it remanded the case to lower courts, and we're going to kind of find out what goes on. I'll talk about that in a bit as well. The two important caveats I want to really emphasize: the ruling does not mean that injunctive relief cannot extend to non-parties in all cases. If complete relief for the plaintiffs necessarily requires the broader relief, a court may still issue a broadly worded injunction or whatever they want to do that guarantees complete relief to the parties in the case. That's the first big caveat that the court states, but doesn't identify how you cabin that. And two, the second caveat is the ruling does not address how injunctions under the APA or class actions certified under Rule 23 of the Federal Rules of Civil Procedure, how they are affected by this ruling. So there's two major kind of caveats, points of interest that we'll have to find out how the courts deal with that below. The few cases that have come out since Trump versus Kaza, there was one in New Hampshire on the same issue, the birthright citizenship issue. On the remand, they took the case, they converted it to a class action, and that, according to lower courts, is fine to issue injunctive relief under class actions versus just individual lawsuits. So the first point for practitioners is likely that class actions may be a better way to get broad injunctive relief than historically individual plaintiff or a one-party plaintiff seeking injunctive relief against all actions in the nation. Class action becomes a lot more valuable after this decision than it was before. Also, multi-state suits are going to be a real way to challenge executive actions, laws. If you want injunctive relief for the entire nation, this shift may particularly matter in environmental rulemaking cases, Clean Air Act, Clean Water Act, NEPA, etc. I think those challenges of APA restrictions are going to be an area the courts are really going to have to grapple with how they deal with those cases in light of this case. One risk of this case is that there's going to be a lot more fragmentation of enforcement with these challenge orders and challenge rules. Instead of getting a universal injunction, which makes it the law of the land not to enforce this law or this order, now I think you might have to do it on geography. You have to go state by state, and you might have cases in which one part of the country is under certain rules, another part of the country is under different rules. And that is the result that the Supreme Court said is the correct result. So we're kind of figuring out how exactly it's going to play out. But that's something we're going to see in the future.
All right. Thanks so much, Jonas. We're now going to hear about another sort of banner case that the Supreme Court handed down in this last term, a case called Seven County Infrastructure Coalition versus Eagle County. This is the NEPA case everyone's been talking about. And to hear about that, we're going to turn to Professor John Ruppel, who is one of, if not the leading experts on NEPA in the country. He previously served our country in the White House's Council of Environmental Quality, which of course works heavily with NEPA. He's going to talk about this case. And before I turn the time to him, let me just note that later this week here at the law school at the University of Utah, in partnership with the Foundation on Natural Resources and Energy Law, we are hosting a NEPA Institute. So that may be of interest to you if this is a case of particular interest. So with that, Professor Ruppel.
Thank you, Lincoln. Let me Okay, hopefully you can see my slide now. So thank you very much, Lincoln. It's my pleasure to talk to everybody about Seven County Infrastructure Coalition v. Eagle County. This is a case about this little red line here. This is a proposed 88-mile rail spur out of the Uinta Basin. It connects into the Union Pacific's existing rail line that runs through Glenwood Canyon over to Denver. So at issue in this case, we have oil development within the Uinta Basin. It's a roughly 12,000 square mile geologic basin. It's rich in hydrocarbons, particularly oil. In this case, the oil is a little unique. It's high in paraffin or wax. What that means practically is as the oil is extracted out of the ground, it's hot, it's warm, it flows very well. But because it has so much wax in it, it tends to thicken or solidify, and it can't be transported in the pipeline. So currently, the oil that's produced in the basin is loaded on heated tanker trucks, it's shipped over Highway 40 and down I-80 up to refineries just north of Salt Lake City. The transportation costs and the difficulty in moving the oil has really limited full development of oil resources within the basin. The Infrastructure Coalition, together with the Uinta Basin Railway Company, proposed to build this rail extension. But before they could do so, they needed approval from the Surface Transportation Board. The STB needed to prepare an environmental impact statement, or EIS, looking at the effects of that development. They did so. They prepared an EIS that looked at the effects of this rail line. They also looked at what they called the downline effects along this existing rail corridor through Glenwood Canyon. And then they also looked at what they called upstream and downstream effects. Upstream being additional production that would occur in the Uinta Basin, downstream being the effects of subsequent refining and combustion of the oil. So when they did so, the STB looked at this and they said, we know there's going to be increased production. We estimate that to be roughly 350,000 barrels of oil per day above and beyond current production. That'll translate into roughly 3,300 new wells. That will the oil produced will result in approximately 10 new trains going down this rail corridor, each of which would be about 2 miles in length. In terms of downstream effects, in terms of refining, they said, we know there will be significant effects from refining and combustion. It's difficult to fully discuss those, but we know that the greenhouse gas emissions will be roughly equivalent to all of Sweden or Ireland's annual emissions. So they complete the EIS, and the STB concludes that the economic benefits outweigh the costs, and they authorize the Infrastructure Coalition to proceed. The Eagle County and Center for Biological Diversity challenged that decision. It went straight to the DC Circuit Court of Appeals, and the DC Circuit made two rulings. First, they said that these, what they call downline effects, kind of the nuts and bolts, typical NEPA decisions about what happens along this existing lane, the risk of a derailment, the risk of a spill, the risk of fire, those things were inadequate. They remanded the decision back to the STB to improve those decisions. That part of the DC Circuit's opinion was not appealed up to the Supreme Court. The other part of the analysis, though, that's more interesting, is that the DC Circuit said, STB, you did good work in being able to quantify the new production, being able to say how much would occur, approximately where it would occur. But you didn't really answer the so what question. You didn't say what that means. So you either have to say what that additional production equates to in terms of effects, or you need to be able to explain why you were unable to answer that question. Similarly, in saying that additional production would be transported to refineries along the Gulf Coast, basically from Houston up into Louisiana, you've identified an area, you've identified the volume of greenhouse gas emissions, but you haven't said so what. You acknowledge that this is an area with environmental justice concerns, with degraded air and water quality, but you haven't said what to do. Now, the STB's response to that was, well, one, we can't speculate. We don't know how long it's going to take out to build this infrastructure and what those impacts will mean. But more importantly, we don't have the regulatory authority to dictate what an upstream producer would do. We don't authorize new wells. We don't regulate the manner in which production would occur. Similarly, we have no authority to regulate the way in which refineries operate or what refineries would. So, as I say, the case goes up to the Supreme Court, and the Supreme Court's decision was twofold. They uh, they said first that the DC Circuit Court erred in failing to afford the STB substantial deference in how it implements these. So the manner in which it implements its existing statutory authority or regulatory authority and the process it goes through. More significantly, they said the DC Circuit erred in requiring the STB to go back and look at those environmental effects, those upstream and downstream effects that the STB could not regulate. And the court affirmed a prior decision from 2004, DOTV Public Citizen, that basically said that an agency is not obligated to look at environmental impacts that it's powerless to either avoid or mitigate. So I think that the takeaway from the 7-county case is that there is some narrowing here of the scope of the NEPA analysis that will likely be required moving forward. How big a difference that's going to be, I think we need to wait and see. There were already some of those provisions in place because of the public citizen case. I have to see how courts interpret it. The court, I think, to me, one of the interesting questions is that they didn't fully address changes made to NEPA itself, to the statute, as part of the fiscal responsibility. Now, the FRA talks about impacts in terms of reasonable foreseeability. But here the court was focused very narrowly on the question of the agency's statutory authority. And I think that is going to leave some room for additional litigation to play out what reasonable foreseeability means. There are a number of different terms that are kind of proximate cause adjacent in Justice Kavanaugh's opinion, and it's not entirely clear, at least to me, what the scope of analysis is. So with that, back to you, Lincoln.
All right, thanks so much, John. I'm sure folks are going to have more questions about the scope and how much has been narrowed by this case in our Q&A. And just a reminder, if you'd like to ask a question before we get to that Q&A, use the button at the bottom of your screen. We can queue the questions before we head into our joint session doing questions and answers. So we're going to turn now to an important case about the Clean Water Act. And for that, we're going to hear from one of our alums who's an attorney in town in Salt Lake City at Dorsey & Whitney. Kayla Weiser-Burton's practice focuses on environmental compliance, including issues regarding hazardous and solid waste. She's an alum of our law school, where she served as the executive editor for environmental issue of the Utah Law Review. So without further ado, Kayla Weiser-Burton.
Thank you, Lincoln, and thanks everyone for being here today. I'm here to present the case of the City and County of San Francisco versus EPA, which is a pivotal case in restricting some of EPA's authority under the Clean Water Act that came down earlier this year. So let's dive right in. To start, I just want to provide a very high level and brief background on NPDES, or National Pollution Discharge Elimination System permits. NPDES permits are issued by EPA or authorized states under Section 402 of the Clean Water Act. And NPDES permits authorize the discharge of pollutants into waters of the United States. And they often include what are called effluent limitations within the permit terms. They're essentially those provisions that specify the quantities of enumerated pollutants that may be discharged by that facility. Now, the statute requires a permit to contain, in addition to these effluent limitations, any more stringent limitation that is necessary to meet certain water quality standards that are imposed under state law or any other federal law or regulation. And it is this particular provision which is at issue in this case. So the permittee here is the Oceanside Wastewater Treatment Facility owned by San Francisco. And this particular treatment facility processes both your wastewater, so water used in a home, as well as stormwater. In other words, the rainwater that doesn't sink into the ground and can pick up pollutants from roadways, parking lots, sidewalks, etc. Now, during periods of heavy precipitation, the combination of wastewater and stormwater may exceed the facility's treatment capacity, resulting in the discharge of untreated waters, including raw sewage, directly into the Pacific Ocean. And it is this particular discharge that triggers the need for a NIPDES permit. So the Oceanside facility has had a number of NIPDES permits over the years, and it was most recently renewed in 2019. And during that renewal process, the new permit contained two what are referred to as end result requirements in the permit. First, the city could not discharge in any way that would contribute to a violation of any applicable water quality standards in a receiving water. And second, the city could not perform treatment or make a discharge that creates pollution, contamination, or nuisance. So in other words, these end result requirements are those permit provisions that don't spell out what a permittee must do or refrain from doing, but instead kind of focus on the end result and make a permittee responsible for the quality of the water into which its discharge flows. So upon receiving their permit, the city appeals to the EPA's Environmental Appeals Board, objecting to, among other things, these two new permit requirements, and the appeals board rejects the city's challenge. So then the city files a petition for review in the Ninth Circuit, where a divided panel denied the petition, holding that Section 1311B1C of the Clean Water Act authorizes EPA to impose any limitations that seek to ensure the applicable water quality standards are satisfied in a receiving body of water. The Supreme Court granted cert in 2024 to address the question, does the Clean Water Act permit the EPA, or authorized state, to impose generic prohibitions in NIPDES permits that subject permittees to enforcement for violating water quality standards without identifying specific limits to which the permitted discharge must conform? In a 5-4 opinion issued in March of this year, the majority of the court ultimately agreed with the city, holding that EPA does not have the authority under the Clean Water Act to impose end result requirements in NIPDES permits. But the court rejected the city's first argument that NIPDES permits could only include technology-based or water quality-based effluent limitations. The court noted that statutory language authorized the imposition of other permit conditions that weren't necessarily effluent limitations, but certainly required and kind of necessary in these types of permits, such as monitoring requirements or the requirement to implement best management practices, as are often found in stormwater general permits. The court did, however, agree with the city's narrower argument that the Clean Water Act does not authorize the imposition of these end result requirements that create the potential for noncompliance based solely on the conditions of receiving water. The court reasoned that the Clean Water Act authorizes EPA to impose specific limitations on a permittee's actions and the quality of its discharges, but such authority does not extend to the imposition of a condition that simply tells a permittee that a specific end result must be achieved and that it's up to the permittee to figure out exactly how they're going to achieve it. So in short, EPA must lay out the specific steps and limitations for NIPDES permit holders and cannot simply require the achievement of a vague goal without laying out the steps to achieve that goal. Another way to look at it, the court declared that a proper limitation is a restriction imposed from without and not a directive that forces a permittee to determine the compliance measures themselves. The court also pointed out and relied on the fact that in overhauling the Water Pollution Control Act into what we now know as the Clean Water Act back in the early 1970s, Congress deliberately abandoned the backward-looking approach that had previously been in place and had penalized polluters for water quality violations. The court went on to say that allowing such end result requirements would also undercut the Clean Water Act's permit shield provision, which protects permittees from enforcement actions provided that they are in compliance with the terms of their discharge permit. Court reasoned that allowing end result requirements would put permit holders at risk of potential harsh civil penalties if they were unable to meet these requirements, even if they were diligently striving to do so. Additionally, the court reasoned the EPA's interpretation would not address how to allocate responsibilities among multiple dischargers affecting the same body of water. And among other things, one of EPA's main arguments was that precluding end result requirements here could limit the ability of permitting agencies to issue or delay the issuance of general NIPDES permits, such as the stormwater discharge permits for construction and industrial activities, as those general permits often contained end result requirements, such as a condition forbidding any discharge from causing or contributing to violations of surface water quality standards of the receiving water. And EPA pointed out that it should not bear the burden of determining what precise steps a permittee should take in order to protect water quality when that permittee is likely to have better access to information and the nature of the operations of that facility to better understand what kind of changes they can adopt in order to protect the water quality of the receiving waters. But the court was not persuaded by this argument and stated that EPA possesses both the expertise and the resources necessary to determine what a permittee should do and is armed with the necessary tools to deal with a permittee who may be slow to divulge the necessary information to inform the specifics of a NPDES permit. Now, there was also a dissenting opinion, and as I noted before, this was a 5-4 opinion, so the dissent was authored by Justice Barrett and joined by Justices Sotomayor, Kagan, and Jackson. And the dissent focuses on the majority's narrow reading of a permissible limitation and simply highlights the commonality of limitations imposing specific end results, but permitting the recipient to figure out exactly how to achieve that result. So in sum, San Francisco v. EPA marks a significant limitation on EPA's authority under the Clean Water Act. And moving forward, EPA will need to ensure that its permit requirements are specific and measurable in order to ensure enforceability and withstand legal challenges.
All right. Thanks so much, Kayla. Before we turn to our next speaker, just again, a quick reminder, if you have questions you'd like to ask for our joint Q&A session at the end of this panel, please use the button at the bottom of your screen. We'll hear next from Professor Beth Parker, whose research focuses on air quality, tribal law, and particularly water security and water law reform. She is a research professor here at the University of Utah, S.J. Quinney College of Law, where she's the associate director of the Great Salt Lake Project and a senior fellow at the Stegner Center. She's going to be talking to us about the Nuclear Regulatory Commission versus Trump case. Professor Parker.
Thank you so much, Lincoln. Really appreciate it. And thank you to everybody who's here today. I loved Kayla's snapshot, so I'm going to start with a snapshot. I'll be covering Nuclear Regulatory Commission versus Texas. So this is a June 2025 case. And in a snapshot, this was a 6-3 decision that was issued this past June, in which the Supreme Court held that only parties formally admitted to a Nuclear Regulatory Commission licensing proceeding may challenge the agency's decision in court under the Hobbs Act, and we'll talk more about the Hobbs Act in a minute. And because the challengers, Texas and a local landowner, were not admitted as parties, the court actually dismissed the case on procedural grounds. So importantly, the court did not decide whether the NRC has authority under federal law to license private off-site nuclear waste storage facilities. However, if you read the dicta in the case, the majority opinion did offer strong signals favoring NRC's interpretation. And then there was a 3-justice dissent that argued procedurally and on the merits that licensing exceeds the agency's statutory authority. So as a result, the court left the door open for future challenges. Yet significant uncertainty remains about the long-term legal footing of private nuclear waste storage outside reactor sites or off-site. So some background leading up to the case. The Atomic Energy Act of 1954, or the AEA, this is a foundational statute that grants the federal government, now the Nuclear Regulatory Commission, or NRC, or Commission, authority over nuclear materials. And the AEA generally prohibits private possession of nuclear materials, including spent nuclear fuel, also referred to as nuclear waste, without an NRC license. And it empowers the commission, the NRC, to issue licenses for the possession and use of the materials under really strict requirements. And for decades under the AEA, the NRC has maintained an extensive licensing regime for all nuclear activities, from reactor operation to handling of nuclear fuel and waste. So in practice, NRC interpreted the AEA as allowing it to license even the storage of spent nuclear fuel at private facilities away from reactors or off-site. And prior to the 1980s, spent fuel was generally stored on-site at reactors, but as storage needs grew, the NRC's regulatory practice evolved to include some standalone interim storage installations approved for 40 years for recurring leases. In 1980, the NRC formally promulgated regulations that authorized licensing private away from reactor spent nuclear storage facilities. And this was pivotal. It was a pivotal regulatory development. It meant that private entities could apply to build these interim storage sites for spent fuel that are not adjacent to a nuclear power plant. And as we saw some nuclear power plants close, this became more important. And these 1980 rules effectively asserted that the AEA has broad licensing power. And then another act that's relevant here is the Nuclear Waste Policy Act, and this is a 1982 act. And this was Congress's response to the nation's growing spent nuclear fuel inventory. It established a federal program for permanent geological repositories and authorized two types of interim storage for spent fuel, either on-site at reactors or off-site at federally owned storage sites. Then there were some ambiguities because NWPA, which is this Nuclear Waste Policy Act, did not include any express repeal of NRC's existing licensing regulations for private storage. So it added new federal storage framework without clearly eliminating the old one. So this ambiguity set the stage for future disputes over whether NRC truly retained authority under the Atomic Energy Act to license these private interim storage in light of these new limitations. So fast forward to more recent years. By the 2010s, we still don't have a permanent repository in operation. There had been one identified at Yucca Mountain, as many of you may remember, but that program stalled and nuclear plant sites were running out of space, so private interim storage was back in play. And in 2018, Interim Storage Partners, LLC, or ISP, applied to the NRC for a license to construct and operate a private away from reactor or off-site spent nuclear storage facility in Andrew County's West Texas, up near the New Mexico border, on an interim basis for 40 years. And under the AEA, ISP needed an NRC license for this undertaking. And the NRC conducted a safety review and an environmental review, including an environmental impact statement, or EIS, for ISP's application. The state of Texas was concerned about becoming a storage site for high-level nuclear waste, and a local business called Fasken Land and Minerals, which had grazing as well as some oil and gas mining, they opposed the ISP facility during the licensing process. However, neither party, neither Texas nor Fasken, were formal parties in the NRC adjudicatory proceeding. So Texas did submit written comments on NRC's draft EIS, but did not seek to intervene or request a hearing in the licensing case, and that will become important in a minute. And Fasken did go a step further. It filed EIS comments, and it actually petitioned to intervene in the NRC's licensing hearing, but the NRC denied Fasken's intervention on the basis that Fasken had not raised any material fact or legal dispute for the hearing. So that denial of intervention was affirmed on appeal by the DC Circuit, and Fasken did not pursue further review of intervention. And then in September of 2021, NRC ultimately granted ISP the license to build and operate this West Texas storage facility. And once the license was issued, Texas, through its state agencies, as well as Fasken, turned to the courts to stop the project. And Texas and Fasken actually filed a suit directly in the U.S. Court of Appeals for the Fifth Circuit. And they challenged NRC's licensing decision. And they they had not, even though they had not been admitted as parties in the NRC proceeding. So they argued that NRC lacked statutory authority under the AEA and NWPA to issue the license at all. In 2023, a Fifth Circuit panel agreed with the challengers, and the Fifth Circuit held that because NRC's issuance of the license allegedly exceeded the agency's statutory authority under both the NWPA and AEA, any interested person could challenge it in court, regardless of their participation. And on that basis, the Fifth Circuit vacated ISP's license as unlawful. And turning to the Supreme Court, and I think I'm close to out of time.
Pretty much. We'll give you one more minute.
Okay. All right. In one more minute, the Supreme Court reversed the Fifth Circuit's holding in a 6-3 decision with Justice Brett Kavanaugh writing for the majority. And the court's holding focused on who is allowed to challenge an NRC licensing decision in court, rather than directly on whether the ISP license was substantively lawful. And the majority concluded that Texas and Fasken were not entitled to judicial review of the NRC's order because they had not been parties aggrieved in the NRC proceeding, which was required by the Hobbs Act. Thank you so much.
All right. Thanks so much, Professor Parker. So we have 2 things left to do. We've heard all about the cases that came down in the most recent Supreme Court term. What we're going to do next is hear about the cases that might be coming up that one might want to watch in the term that just began last month. So for that, we're going to turn to Professor Brigg Daniels, who's a professor of law here at the law school and the co-director of the Stegner Center. His work is wide-ranging. He has a new book that's about to come out on the history of environmental law through NYU Press with Alex Camacho. And so with no further ado, Professor Brigg Daniels.
Thank you, Lincoln, and I appreciate everybody hanging in there with us. So just to give you a quick overview of what the court has accepted so far, the basic take home here is that we don't have a lot of really exciting environmental law cases specifically in front of the court right now, which some of you might see as very good news and some of you might see as bad news. But it's still early days, and a lot of the most meaningful cases, except to the last term, happened after this point in time. So, but that being said, there are a few cases that are heavy hitters that have extremely important implications for environmental law. I just want to talk about a few of those, and then I'll give you a little bit more background of what the court has taken on that touches environment. Specifically. So the first case, Trump versus Slaughter, this is a case that is scheduled for the Supreme Court in December. It has 2 major questions presented, but the one that is most important here is whether the statutory removal protections for members of the Federal Trade Commission violate separation of powers, and if so, whether Humphrey's executor versus United States should be overruled. For those of you who've taken administrative law in law school or have dealt with administrative law in any meaningful way from the appointments perspective, you're probably familiar with this case. Basically, there's but a line drawn between the president's removal power, and Congress can put various hurdles in front of the president of removing folks, including good cause, which is the case here. This case is important for a couple of reasons beyond sort of the administrative law wow factor. And at the most broad level, this case presents the most obvious entry point for the court to push the unitary executive theory. This is the idea that the president should have control, entire control of the executive branch. This theory was once pretty obscure. It now appears that a majority of the court is willing to adopt the theory. So this is important for governance generally. So for example, depending on how this case goes down, it might greenlight some of the efforts that courts have been reluctant to completely allow. And particularly I've been thinking here, dismantling the civil service requirements that could lead us to something like the form or spoil system that was in place before that was put into place. On the narrow question here, whether President Trump can fire the Federal Trade Commissioner, this would have obvious implications for independent agencies that have environmentally adjacent missions like the Federal Energy Regulatory Commission and the Nuclear Regulatory Commission. The second case that I want to highlight here is called Trump versus VOS Selections, and it's set for argument tomorrow. This is the tariffs case. And the major questions here is whether the International Emergency Economic Powers Act authorizes tariffs imposed by President Trump, and whether the same act authorizes tariffs, whether statute constitutionally delegates legislative authority to the president. There are a few reasons that this case, which is mainly focused on whether the president can unilaterally erect tariff barriers, is interesting for those who are interested in environmentalist policy. One question here is the major questions doctrine, and whether or not the court will apply it here, and if so, how. Will the court find an exception, meaning that the major questions doctrine somehow contracts, or will it continue to make a major part of its jurisprudence? Beyond major questions, there are just a lot of questions revolving around executory power, particularly the issue of whether or not the expansive reading of the statutes, the way that haven't typically been allowed in the past, that might contradict what it seems the plain language of the statute would say is allowed here. Should it matter that the president is exercising this power rather than agencies, and if so, how? Again, this is another possibility that the unitary executive theory could find footing. A second issue, assuming that the justice will grapple with the executive power, and particularly the power of the president to declare an emergency, is one that has been highlighted by colleagues here at the law school, Wesley Peebles and Tom Mitchell, both affiliated with the Stegner Center. They recently published in Environmental Law Reporter an article that highlights the similarities of the tariff cases and energy emergency used to push the expansion of mining practices and critical minerals here in the United States, particularly on federal lands. A third issue, and this is one that Dan Farber, professor at Berkeley, flagged on the blog Legal Planet this morning, is whether or not the power to regulate includes the power to tax, which if the court takes a bite of the case in this direction, it might have all sorts of implications for regulatory agencies, including environmental agencies across the bureaucracy. The last thing I'm just going to highlight here, just very briefly, Louisiana versus Calais. This is whether or not this has already been argued, and it appears that the court is going to constitutionally invalidate Section 2 of the Voting Rights Act, which prohibits gerrymandering on the basis of racial impacts. If this is struck down, this would probably eliminate a dozen or more seats to the House that swing to the Republican side of the ledger. As it is said before, elections have consequences, so do electoral cases, and this one might have very profound environmental consequences. Just a couple of cases here that, well, just one case that has specific environmental impacts. Enbridge versus Nestle. This is a case that the court has agreed to hear, which focuses on whether a district court can equitably toll the legal time limit for removing a case if circumstances call for it. The reason that this is interesting is that the circumstances here that might call for it in the equitable context is the need to build infrastructure, particularly gas pipelines. If the court sides with Enbridge, this might open up a loophole for energy development and many projects that the Trump administration is anxious to pursue. If I have another minute, Leakin, I'm just going to give you one more. Chevron versus Pelican Mines Parish. This case on the outside looks like a civil procedure case. It examines whether the Fifth Circuit is allowed to remove venue for a federal officer. In this particular case, the Fifth Circuit has allowed the removal of an officer here in the military because it deemed what was necessary. The national level was locally unpopular. Again, what is locally unpopular here is damages by military complex for creating aviation fuel to local coastal areas in Louisiana. I have a couple more, but I'll reserve the time, whatever we have left. I know we're running short.
Okay, thanks so much, Professor Daniels. So we do have about 5 minutes left. We're going to use those for questions and answers. And again, if you'd like to ask a question, use the Q&A button at the bottom of your screen. I'm going to ask all of the speakers to join me on the screen for a moment so I can call on you as questions come up. The first question, perhaps unsurprisingly, is about the NEPA case, the seven-county infrastructure case. So this is for you, Professor Ruppel. The question is, what does that case have to say about impacts of a federal decision that might be downstream, separate in time or place, but actually regulated by the same agency?
I think it's a really good question. I think the starting point as I think through this is to think about the statutory authority granted to the particular agency. So let me give you a quick example. Imagine we're talking about the Forest Service or the BLM. They are obligated to manage tens, hundreds of millions of acres of land. They're required to develop land or resource management plans that cover that vast acreage that set forth a vision for the next 15 to 20 years. And in doing so, they're obligated to think about multiple use and sustained yield, and they have a lot of discretion in exercising. So I think in that case, it would be much easier for an agency to take a more fulsome view of those kinds of impacts that may be further down line, more remote in terms of place or time. However, in the seven county case, the STB's jurisdiction or authority was a lot narrower. It's a little bit of a dispute that came out more in the DC Circuit opinion in front of the Supreme Court. Basically, in the DC Circuit, the court said that they have to complete a public interest review. That included weighing the environmental consequences, and that would be enough to reject the proposal. The Supreme Court looked at it much more narrowly. Didn't go into deep analysis here, but basically they said that rail lines are common carriers, that the STB is obligated to grant permission without regard to what that rail line would carry. So here they didn't have a lot of discretion, at least in the mind of the Supreme Court. So assuming that you do have that discretion and space, I think the other part of the answer is, how is the court going to look at the way the agency exercises that? I think the answer here is we're going to see more deference to the agency. If the agency is to say, look, the analysis is speculative, I think, or as long as they explain what they're doing, I think there will be more deference due to that agency decision.
All right, thanks so much. We have just a couple minutes left. Let me turn to Professor Anderson. There's a question about whether there's a relationship from the Supreme Court's recent overturning of the Chevron doctrine in Loper-Bright and the Trump v. Casa case, which I think maybe speaks to how one might challenge agency rules going forward.
Yeah, not a direct connection. The Casa case is really about do courts have the authority to issue nationwide injunctions or universal injunctions in single plaintiff or multi-plaintiff cases? The answer to that is no. Does Chevron have any impact? Does it have any impact on the Chevron case? I don't think any more than any other case out there. A court like the Supreme Court can overrule Chevron law or any statute that Congress passes. What judges can't do now, a district court judge, say in Utah, is limited in the ability they have to say, we're not going to enforce this regulation in Utah and everywhere else across the nation, even though the plaintiffs are just based in Utah. And so that's the remedy part you need to think about as a practitioner. When you think through your case, you now need to think, can I get complete relief that involves the entire nation? And that's really where the case is going to impact the practice.
Okay, thanks so much. So with that, we're at time. Let me take just one last minute to first thank all of our panelists for joining us here today, and to thank each of you out there in the audience for joining us. We'll continue to do this each year, so watch for us again next fall talking about the Supreme Court cases that were previewed a bit by Professor Daniels and how they turn out. The second thing I'll just do is note a couple of our upcoming programs here at the Stegner Center. It's a busy week coming up. We have, as I mentioned, the Special Institute in conjunction with the Foundation of Natural Resources and Energy Law here at the law school this Thursday and Friday, November 6th and 7th. There's details about that on the Stegner website. And then also this coming Monday, November 10th at 7 p.m. at the Natural History Museum of Utah, we'll have a special conversation between Jennifer Napier Pierce, who's the former editor-in-chief of the Salt Lake Tribune, and our dear colleague Bob Keider about his new book, Conserving Nature in Greater Yellowstone. That should be a terrific event. It's free to attend if you register. So we hope to see you all there and at our upcoming programs, including our 31st annual Stegner Center Symposium that's coming March on public lands. So again, thanks to each of you, thanks to our panelists, and have a great day, everybody. Take care.